Okay, so quite a few folks to trickle in, but that's going to happen, I guess. Oh, now I got to remember who's who here. I think I got this right. Sean, I'm going to spell your name wrong here, I think. I hope I spelled it right. All right. I think I have Roxanne and Shauna in the right spots here. Okay. Oh, Shauna's not got her audio on anyways yet. Okay. Before I get into my stuff, are there any questions about anything that we looked at this morning? Okay. So what we're going to do for the first part of the afternoon is really a review of what we saw back in chapter 6. Okay. In chapter 6, I introduced a bunch of estate planning concepts so that we would have all that language available to us as we worked through the subsequent 10 chapters. Now we're into chapter 15, and we're going to delve into estate planning to a greater level of detail. And that means that we have to revisit this language. I want to make sure that we have all of this down so that we can actually have a useful conversation as we go through the rest of chapter 15. Okay. Are there any questions then before we get rolling? Makes me nervous, the number of people that I don't see here yet. Oh, there's something wrong with the waiting room. I normally get a notification when there's people in the waiting room. Yeah, so exactly. Remember in chapter 6, Todd, we talked about bankruptcy and insolvency. We talked about estate planning a little bit. We talked about separation and divorce. And we talked about promissory notes and ownership of property, right? I know you remember all of those things well from chapter 6. Okay, so really we introduced wills and estates there just as a way to, again, have those topics available to us. But now we're going to really dig into it. Okay. Now, to be fair, we're still not going to go into full depth here. There's also an estate planning chapter in advanced curriculum, and that's where we're going to, well, I only remember everything about this course, Todd. I forget a lot of other things. So we're going to, in advanced curriculum, that's where we're going to deal more with concepts like trusts and buy-sells and some of that stuff that impacts higher net worth folks or folks who have more complex scenarios. Okay. So we're going to look at our core estate planning documents, which is really a straight back out of chapter 6. We'll talk about probate and what that means. We'll talk a little bit about taxes at death, which we've already done some of, which is good. And we're going to talk about estate planning objectives and creating a financial plan. Okay. So, and I'll point out here that we're going to be done Unit 5 right here. So that'll be the end of Unit 5. And then those last 4 days, we're so close to the end now, aren't we? Those last 4 days, just a little more than a month away, that's all going to be chapter 16. So that's where we're going to do some case study work. We're going to do some really more behavioral side of financial planning stuff, which we've talked about a fair bit already. Even in that discussion we had before the break, we talked about behavioral factors associated with whether to take the pension or not. Okay. Just the end of the core curriculum, Todd. Right. But you're right, there's still a lot left after that. Yeah, about that. Yeah. Okay. All right, so what are my 3 core estate planning documents? The 3 documents that are going to form the heart of any estate plan. Will, perfect. power of attorney. And we're not going to do a sample will here, Todd. I don't. I know there's one in one of my competitors' course material.
Executor.
Sorry?
I meant executor.
I see. I thought you meant example. Sorry, I apologize because you asked to do a will and then, okay. Never mind then. No, we don't do a sample will. All right. Which is not an answer to anybody's question. We're going to talk about so the executor's involvement with the will in a moment here. You're right. That's a massively important part of writing a will. My third document is going to be my healthcare directive, or whatever name it goes by in whatever province you're in. It's something called a personal care directive, or an advanced care directive, or a living will, or a power of attorney for healthcare. I think those are all the names we see applied to it in Canada. And actually, there's nowhere in Canada that legally calls it a living will. Yes, it answers that important question, right? So, power of attorney for healthcare, okay? All right, so the will itself, this is going to answer the question, what happens to my stuff and my obligations when I am gone? Okay, so I'm no longer there. I don't have to worry about taking care of myself. This stands in contrast to your power of attorney. Now, I will comment there are two kinds of powers of attorney. So just so that we're fully aware here, we have what's often just called the general power of attorney. This is an administrative document. This is not our estate planning document, at least not usually, although sometimes it does have a hand in an estate plan. But this is just an administrative document, and all I'm doing here is passing responsibility for my legal affairs to somebody else. And this is usually used just for simplicity and convenience. If I would be absent from the country for an extended amount of time, and there's going to have to be documents signed, instead of trying to track me down and courier documents to me somewhere else and have them notarized by a notary who has authority to notarize documents for Canadian purposes, we're just going to give somebody else that ability to manage our affairs, okay? And you don't see that done all that often. That used to be more common when it was harder to get documents to folks who were in another part of the world or whatever. But today, you won't see much done in the way of general powers of attorney. What we are concerned about here is the is a springing or enduring power of attorney. And in a springing or enduring power of attorney, this document usually has, although you can combine the two documents, but this document has no authority until there's a triggering event. And that triggering event is usually the loss of capacity of the grantor, which is the person who drafted the document. Okay, that's good. And the idea here is that then we're going to have an attorney, which is not the same as a lawyer, okay? Anybody could be an attorney, or pretty much anybody could be an attorney. So on the loss of capacity, an attorney, which is somebody who is legally granted power by this document, makes decisions for the grantor. Okay, so this really answers the question, how will I be taken care of? It's a little different than the question we're answering with the will. This answers the question, how will I be taken care of financially when I can't make decisions any longer. Okay, that's all good? All right, and then we have our living will or its various iterations. And this is actually going to take a very similar format to a springing or enduring power of attorney. So this is where we're going to answer the question, how will my healthcare decisions be made when I can't exercise any decision making? Okay. Now, I'll comment just briefly on the healthcare directive or the living will or whatever this document is called. We do have legislation to support this. However, it's a little bit iffy whether this legislation is going to have meaningful effect. So ultimately, the decision still rests with your healthcare provider. Okay, your physician is the one who really decides, to your comment, Todd. I know you're kind of half joking here, right? But your physician is still the one who ultimately decides when to pull the plug, okay? Or whatever the decision is. The idea here is that under this type of document, the physician knows who you would prefer that they talk to about that decision, okay? But ultimately, it is still on the healthcare provider to make these decisions. Okay. Yeah, that's really good, Grant. Many people don't do that kind of, I mean, not good that you got sick, right? But many people don't do that kind of thing. Many people write the document and just assume that it's going to take effect as they intend. And that often does not happen. And in fact, what will happen in most hospitals is if you end up in the hospital, instead of using the power of attorney for healthcare document, the healthcare providers in the hospital are essentially going to communicate with the first kind of close family member they see. And they're going to use that person as their primary kind of guide for decision making. So good that you've done that, because presumably you've bypassed what would be the normal administrative process in the hospital. That's good. So Grant's comment here is quite valid. And especially if you have somebody who is sick, so somebody who's fighting cancer or whatever the case is, and they still have their capacity, it's good to, if they don't already have these documents, to write them, and if they do have them, to review them with their healthcare team. Okay, so then with the will, we're going to identify the parties involved in the will. Okay, so we're going to have the drafting lawyer or the drafter of the will. Yeah, so we're going to talk about that later on. Bonnie, you're quite correct. A blended family situation is a classic example of where this gets messy. Okay. So we're going to have the drafting lawyer or the drafter. This is the lawyer who wrote the will. Okay, this is the solicitor or lawyer who wrote the will. And in some provinces, it could be a notary. Some provinces, like British Columbia, for example, allow notaries to write wills. Not all provinces allow that, or at least not all provinces allow them to charge for it. Generally speaking, really anybody could write a will. The question is whether you make a living doing it or not. Okay, then we're going to have the testator or testatrix. And this is the person who is writing the will for themselves. So they're not the actual one who's writing out the documentation, but this is the person who's essentially creating the will for their eventual death. And then we can have the executor. This person goes by a bunch of different names. If we're going to go with the Latin here again, we sometimes talk about executor or executrix, but also we can talk about the estate administrator or the estate trustee. That's sometimes a term that you'll see here. Those are all essentially the same function. And this is the person who's actually going to do what your will indicates needs to be done. Or is left guessing if your will isn't prescriptive enough. Whichever it is. Okay, and then we're going to have our heirs and or beneficiaries. And usually we're going to use the term here beneficiary to refer to a specific person. So that is anybody who's going to receive some portion of your estate when you're gone. Okay. Does that all make sense? Perfect. Okay, let's keep rolling then. Okay, so what is your estate? When we talk about your estate, what are we referring to here? Well, what happens if we think about this? I'm going to draw a line here, although not a time value of money line. Okay. So we have somebody who is alive, doing well, everything is just fine. Okay. And then this person dies. So let's say for the sake of argument that our testator dies on the 1st of September of 2020. Okay, so this person dies, they're no longer here, no longer alive, and now we have to figure out what comes into being. So from a tax perspective, and we'll talk about this in more detail in a couple of minutes, on the day you die, we're going to have your terminal tax return. And there's actually up to 4 tax returns that can be filed as of the date of your death. So we would talk about filing your terminal tax returns. That's done by your executor. So assuming you actually wrote a will and named your executor, that's done by the executor. Following your death, then your estate comes into being. And what your estate is, it's you without the physical part of you, at least from a legal perspective, that you can touch and see. Okay. So it's you without your physical self. And what this really allows to happen, it gives all the folks that you interact with an opportunity to wrap up whatever business they had with you. That might be payment of debts. That might be your gifting property to people. That's going to be some taxes paid potentially. Now, we don't necessarily need an estate. And I know we chatted about this once before, but there's a small number of cases where no estate is required. Probably not so for most of your clients, but occasionally, if you have somebody who dies with very little property, then we may not need an estate. And usually the trigger here is bank accounts, okay? And I know we talked about this back in chapter 6, that there will be some dollar amount where the bank manager is going to have discretion to say, yeah, I can distribute that amount without having probate or without having an estate really created. And if you can do that, then you're going to be okay. But generally speaking, if you have even a car, a house, any real investments, GICs, mutual funds, stocks and bonds, we're going to need an estate to be created in order to deal with the distribution of those assets. That's good. Okay. So it might be, and again, this is going to vary, but maybe $5,000 or $10,000 of assets. And the bank can distribute those assets. It's going to depend, Paul. It'll depend on the, excuse me, on the financial institution. 10 is a good range, though. That's a healthy thing to think about. And they won't always do it. You could have somebody who's got $8,000 in the bank account, but the bank manager isn't sure that they would be distributing that amount to the right person. They're going to make you go through this process. Okay. I 100% do not, Bonnie. I couldn't disagree with something more. All right. You would have a hard time finding a concept in this course anywhere that I would more vehemently argue against. Is that fair? No, it's not at all. Remember we talked about the Pecor case? Do you remember this, Bonnie? This was the joint ownership case that went to the Supreme Court of Canada because dad had done exactly that with his daughter. We will talk about that case. In fact, I think we'll talk about that case this afternoon. Okay. All right. That's, you know, the Batman slapping Robin meme, Bonnie? Okay. One day I'll build that for that scenario. All right. Joint with spouse is different, Philip. Joint with spouse makes a lot of sense in a lot of cases. That's a whole different question. Okay. All right. Good. Okay. And I think, Bonnie, if you asked any estate practitioner in Canada today about that, they would give you a similar answer. Okay. Maybe without my Batman slapping Robin meme. Okay. All right. Yes, I know people do it. And in Alberta, of all things, Bonnie, that's the most ridiculous thing, to do that in Alberta. It's insane. Okay. Yeah, absolutely. Max $525 of probate fees. Yes, the money might move quicker, or you might end up at the Supreme Court, whichever. All right. And in fact, did you see, Bonnie, I put out a new YouTube video maybe 2 weeks ago. Of course, if you subscribe to my YouTube channel, Bonnie, come on. So I just put out a new YouTube video about that very thing. And there was a recent court case that actually used that precedent, actually 2 in that video, if I remember right. No, 1 that used that precedent and really applied that in an unexpected way, honestly. We'll talk about that later on. We will. Okay, so just going back to my estate. Yeah, that's one of the risks with it, Paul. That's technically joint ownership. We talked about this back in chapter 6. Technically, joint ownership means that both people own that property with an undivided interest, which means they both are 100% owners of that property. Yeah. Okay, which means that your client's, I guess, brother did not, or Yeah, your client's brother did not do anything illegal. Maybe immoral, but not illegal. Okay. Now, if they left their parent without enough money to pay their bills, that might be a different story. There might be some elder abuse there, but that's a very hard thing to demonstrate. Okay, so yeah, nothing good about that. All right, so the estate then is going to be administered by the executor. And in order to do this, the executor will need letters of administration or a grant of administration. Depends on the province you're in, but there will be some documentation here that says, yes, in fact, this person is the executor. The will names them, and the courts agree that they're the one who's supposed to be doing this. Okay. The executor is a fiduciary. That's something else we talked about in chapter 6. The executor is a fiduciary. However, it's not really clear who they are a fiduciary to. So they might be a fiduciary to the deceased person. They might be a fiduciary to the estate. They might be a fiduciary to the beneficiaries. I'm less prone to take that perspective. Okay, now what is true, regardless of who they owe that fiduciary to, what is true here is that they can't do anything to artificially enrich themselves unless the will specifically indicates they can. So it's very normal to have an executor who is also a beneficiary, and then, yeah, that person can do things to make sure that they do get paid. Or most wills that are done by good lawyers are going to include specific commentary about compensation for the executor. Okay, so now once the estate comes into being, the estate will stick around long enough to wrap up all of its affairs. For most people, that's going to be less than 12 months. Usually, this thing is going to just be wrapped up. We can distribute all property, and we're going to be okay. For more complicated estates, this can take longer. It wouldn't be unusual if a high net worth person who has assets in other countries dies. Might take somewhere between 2 to 5 years to wrap up. And if you get legal disputes, so where you have legal disputes for whatever reason, an estate can drag on for decades. Okay. Right, so one of the things that would make this more complicated, Paul, is not having a will. Lonnie, I know you told this story when you were in class with me before. I vaguely recall that you're in your family, there's a messy estate ongoing, right? Or is that the power of attorney in your family? Okay, I couldn't remember. I knew you had something. Yes. Okay. And yeah, a good example of a more complicated estate is not to have a will. Okay. So don't get a will, and that makes a complicated estate. And a lot of times people who would have an easy estate if they had a will don't bother with a will. And then especially if you get a blended family type situation, or if you get somebody who just doesn't agree with the distribution, then that can be messy. Okay. The longest existing estate that I am aware of is an estate for a family that had property just outside of Toronto, just north on Highway 27, just outside of Toronto. And that estate went from 1969 to 2014, I believe, might be 13. Okay. So that's a long time, right? And that's what happens when, and in this particular case, it was a combination of things. It was a combination of sort of trying to disinherit one child. And we'll talk about disinheriting kids later on. And that child turned out to be particularly angry and really fought for a very long time about this. Okay. Good stuff, Paul. All right. Yeah, those are messy scenarios, right? And there is that perception. Some people, for whatever reason, make this connection where they say, once I get a will, I'm ready to go, and therefore I'm just going to die as soon as I get a will. Okay. Okay. So that is something you can do, Todd. Of course, the problem there is, when are you going to die, right? So many of our financial planning problems are solved if we know exactly when we're going to die, right?
I have a case like this where there's 4 children and 2 children got close to the one parent that was living, and they got them to move all the money to them. And there's millions of dollars in the estate. And then when they died, each other child only received $1,500 from the estate.
So there wasn't actually millions of dollars in the estate. There would have been, right?
There would have been. So they ended up, months before the parent died, convinced them to move all the money to them. But then how do those kids go after the other kids go after that money? It's like it's pretty hard.
It's hard. Yeah, they can make an argument about undue influence. They can argue that what looked like a gift was in fact not a gift, or that mom and dad didn't have capacity to make a gift. But those are difficult arguments to advance. And we're going to see some of those come up as we work through the afternoon here.
Especially when the client passes away from dementia, severe dementia, and had dementia for the past 3 to 5 years. I think it would be easy to prove in court, but
Yeah, that would be a strong bit of ammunition for somebody who's looking to fight those gifts. I'm surprised actually if they're not going to court on that issue. Okay.
Not with COVID, because everything's on hold.
So that's true, sort of actually. BC is back though. BC does have court processes ongoing, but yeah, there was about a 4-month hold really on legal proceedings, but we're seeing it now. We're seeing courts get back into action. Okay. See court cases being done by Zoom now and all that good stuff. All right. Are we good with the concept of the estate? Do we get this? We understand what the estate is? Okay. All right, so related to that, what is probate? Yeah, you've done honestly, New Brunswick, especially New Brunswick put the bubble in tight early on, right? Okay. So death and tax, not just Canada, right? Everywhere. Okay. So probate, this is a fee or tax. Now we'll talk about that in a moment, assessed by the province to ensure that the will is executed properly. Or in the case of no will, the intestacy is executed properly. So the idea here is that I know we often take these extraordinary steps to avoid probate. Bonnie talked about this with this ridiculous joint ownership situation. Okay, which again, I will say I do not support from parent to child. You probably could come up with a scenario where I would agree with it, but I think we'd have to jump through a lot of hoops to get there. With spouses, perfectly fine. Okay, spouses, that's perfectly fine. Yeah, it's not a ton of money, Mark, right? The amount varies. So there are a few provinces, Alberta, for example, is a $525 maximum. In Saskatchewan and Manitoba, it's 0.7% of the value of your estate. In Ontario, do BC here first, sorry, BC is at 1.4%, Ontario at 1.5%. Paul, in Nova Scotia, you're at 1.533%, is that right? So, and that's the most expensive. Nova Scotia is the most expensive in the country. And even there, on $1 million of value, you're looking at $15,000. Now, if you have illiquid assets and no life insurance, that's a problem. But if you have any sort of liquidity, should not be an issue to come up with the money to deal with this. And I really do find this, that often the steps we take to avoid this have higher costs and more negative consequences than just paying this. Okay, now Bonnie did point something out a minute ago that ties into this, that there's going to be a little bit of a delay here. Okay, the courts will essentially impose delays. They are not going to allow property transfers to happen right quickly. It depends on the value of the assets though. Smaller assets generally can be delayed distributed really quickly, but larger or uncertain assets really have to wait until debts are settled. And that's more about executor's liability than anything else. So the problem here is that the executor doesn't want to distribute assets until they're certain that they're not going to have any personal liability for a failure to properly handle the estate. Okay, I mentioned that on the last slide, that the executor is a fiduciary, and in that fiduciary capacity, you do have personal liability for something that hasn't gone right. Okay, is that all good? All right. Now, there's a curious thing with probate, and the reality is that in Alberta, it's a fee, and in other provinces, it's a tax, okay? Or at least in the flat fee provinces, it's a fee, in others, it's a tax, and it's a tax because it's a percentage of the value of your assets. That does mean in those other provinces that if you're going to amend it or whatever the case is, there's more work for the government to do this. Okay, now this does beg the question, what assets are probated? So, well, now it's too late, Paul, right? Okay, so yeah, essentially anything that passes through the estate, and it's actually probably easier to answer the question, what's not probated? Okay, so what's not probated will be life insurance, seg funds, return of premium benefits, RRSP and its ilk, so RSP, RIF, DPSP. Well, I'll add joint accounts in a second here, Paul. LIF, LIRA. Okay. Pensions, to the extent that these things have beneficiaries. Okay, Todd is correct here. This is only true if we have a non-estate beneficiary. Okay, that's good. Oh yeah, I missed TFSA, thanks. All right. And we've looked at a bunch of that stuff already. Now, joint accounts are a little bit different. So if you have a joint with right of survivorship account, that's also not probated. Okay. And that's true. We see a bunch of survivorship type accounts, so that's not probated. Now, we can also look at what happens with an RESP. So with an RESP, if the subscriber dies, we ask the question here, is there a joint subscriber or a successor subscriber? And if there is, then it's going to bypass probate, but otherwise your RESP can be a probated asset. That's good? Right, exactly, Paul. So I would often own my house jointly with my spouse, although I don't actually, Paul. My house is only owned by my spouse, but physical property is going to have to be probated in almost all cases. Okay. Now I will show you later on, we'll talk about trusts. Trust can help to bypass probate, but we're not going to talk about that until advanced curriculum. And we'll talk about a couple of other strategies there as well. There are ways to use a trust to get around probate. So anyways, back to physical property. Yes, your home, any sort of rental property, farmland, vacation property. Okay, unless of course it is jointly owned with your partner. Yeah, exactly, Todd. So you're on the intangible side. That's where we would have your investment accounts, your non-registered investment accounts. Exactly. Your non-reg bank accounts, shares of a family business. Okay. Again, as long as it's not sitting in a registered plan. Just back up to my physical property. I should throw on here vehicles. Bonnie's parents' motor home would be a probatable asset. Okay. That's good. Stephen's favorite boat would be a probatable asset. All right. The other comment I will make here, and I don't know why this comes to mind so readily right now, but anyways, there are significant differences in probate regimes in other countries. Okay, right, because then you don't own it, Todd. Yes, that's right. Property you don't own is not probated. So there are lots of different versions of this. Okay, and you can't assume that what would be the case in Canada would be the case in another country. Even to some extent, what happens in Quebec is a little bit different from what we see in the rest of Canada as it concerns probate regimes. All right, that's good. Any questions on probate? I will actually specifically comment on Ontario here. So Ontario has probably the most, in fact, definitely the most aggressive probate regime in the country. In 2016, if my memory serves right, Ontario introduced its Estates Administration Act. And that Estates Administration Act is where we see probate described. For those who die today in Ontario, their executor really has their work cut out for them. To the extent that you're effectively cataloging all the personal items that you find in the deceased person's home and making sure that they are properly valued and probated. Okay. It's based on residency, Paul. So the question here is one of residency. It is a good question, and not a terribly complicated question, although you can have some complicated answers. But let's say, blue here. So let's say that you have, I'll try this. We'll see how this works. So that didn't work at all. Do we know what that is? I'm close anyways, right? So I can't move my Vancouver Island. Okay, so there you go, Nicole. I knew you'd like it. All right, perfect. So people are somewhat aware of what I've just tried to draw. So yes, if I have somebody who dies as a resident, so let's say I have somebody who lives in Calgary, but has some property in Kelowna. This would be a common enough scenario, right? So I have a resident of Alberta who dies. All their intangible property located anywhere in the world, plus their tangible assets in Alberta, are probated in Alberta. That's good. But they own that property in Kelowna, so they have a tangible piece of property in Kelowna. That asset is going to be probated in British Columbia. Okay. Is that the answer to your question, Paul? It's not actually that complicated, right? But you can see how this leads to complicated outcomes. Because the question that this begs then is, do I need a separate will in British Columbia? Okay. Now, the answer to this question is no, you don't need a separate will in British Columbia, because a will written in Alberta is going to meet the conventions we see in British Columbia. It'll be perfectly fine. The judge in BC will say, yeah, I'll just use your Alberta will. That's good enough. That's fair. Where this gets more complicated. Okay, so that's a different question, Paul. Hang on to that question. All right. So where this gets more complicated, there you go, Esther, is US property or property on a reserve. So with US property, it's often the case that you do want to write another will. So in a case like that, it would be common to have your Alberta will plus your, let's say, Arizona will. Okay. Now, actually, Arizona is not too bad. You probably wouldn't bother there. You probably would use your Alberta will for your Arizona property. But if it was California, where estate laws are a little different, or Florida, where estate laws are outright wacky, you probably would have a different will. Okay. Right. So physically relocating to British Columbia, it would depend, Todd, how much stuff you owned. For most people, just changing provinces would not be a reason to change your will. It might be a reason to update your estate plan. That's a different question. And if you had adult children, you might need to rewrite your will because you have to rewrite your estate plan because BC treats adult children a lot differently than Alberta does. But just by default, switching provinces. Are you sure about that, Todd? Yeah, that honestly does not sound right to me.
It's in the new BC Will Act that they changed. So yes, they won't recognize a will outside of any other province than BC if you're a BC resident.
So I'm going to look that up because if that's true, that's in contravention of one of Canada's international treaties.
Well, it's supposed to be true because they changed the Will Act in BC, and they won't. If you live in BC and you die in BC, you have to have a BC will. If you have a will from another province, it won't be recognized. I've heard that at seminars. I've heard that from my lawyer.
I want to check that because
You look into it.
Yeah, it'll be easy to check. So, yeah, because Canada's a party to an international wills convention that does require recognition, at least of the format of a will, from 23 other countries. So, and the new, just for what it's worth, Todd, the new legislation in BC that came in 2015 or 2014, sorry, was actually essentially a copy of the same legislation that came in Alberta a year earlier, with a few little BC tweaks to it. So yeah, both provinces actually did their wills update very close to one another. Okay, but I'll check that. That's an interesting point. If that's the case, I'm not aware of it. Okay, so the other question that came up, yeah, the reserve property question. So this is where you get into, Paul, a question about what each particular reserve has done, okay? So essentially when you have, and it's even difficult to actually own property on a reserve, Paul, right? Sometimes it's a long-term lease, sometimes it's really an ownership, but for property on First Nations reserve, basically the reserve at some point might have made a conscious decision to be governed by the province's law. Okay. So they might actually have essentially elected out of their treatment under whatever treaty they're under. And in that case, you're just using provincial law. Okay. Otherwise, this falls under the Indian Act, and you've heard me be critical of the Indian Act before. The challenge with the Indian Act is that it generally restricts you from being able to transfer property unless you have the consent of the minister, which today in Canada, it's the Minister of Indigenous and Northern Affairs, if I remember right. And what that really means is that you have to jump through some additional hoops to write that will in the first place. So that's what you really have to establish here, Paul, is whether the property in question is on a reserve that uses the provincial law or whether it still falls under the Indian Act. Okay. All right, that's all good? Okay. So then we'll look at the executor and the role of the executor. Okay, so first off, what should happen here is if you have a will, let's try that again. If you have a will, you almost certainly named an executor. Okay, and hopefully a contingent or two as well. Okay, now that being said, there's a bunch of different types of executors that I can name, or a bunch of different ways that I could do this. So my executor could be just an individual, could be one individual. Okay, or what I could do is I could name a committee. And if I'm going to name a committee, I can do all kinds of things here. So I could have one person who is responsible for most matters, but then any decision worth more than $10,000, they have to get the consent of another person. Okay, you could really do a lot here. However, the problem with that is that you're not necessarily achieving better outcomes that way. We don't know for sure that that committee is actually going to function. Or what you can do is you can name a corporation as trustee, sorry, as executor. I'm actually a big fan of this. I think for people with more complicated estates, this is a good step to take. This is where we would name a professional executor. And this is a way to sort of detach the decision-making associated with handling the estate from any sort of emotional entanglements. So this should reduce the possibility of fights. Or put a different way, yeah, so Paul, I'm not a fan of joint. I am honestly not, okay? I'm not suggesting that that's a good idea. It's just something you can do, okay? I do like the corporation as executor. The biggest problem with it is it's going to be expensive. Okay, it'll cost somewhere between 1 to 5% of the value of the estate. That's typically a fee that's agreed upon before you write the will. And the executor says, if you're going to name me, if you're going to name this entity, this is how our fee schedule goes. You just take that fee schedule, give it to your lawyer, and put it right into the will. Okay. I think there are many people who would be well served by a professional executor instead of trying to use a family member, especially you get into high value assets, blended families, you get all these complexities that one person, especially somebody who doesn't maybe have a ton of financial acumen, might not be well suited to deal with. Okay, if there's no will, and we'll talk about intestacy on the next slide, but with no will, the courts will appoint an executor. Sometimes they're law firms, Paul. No, often they're not, though. Most of the professional executors I know are either trust companies or people who just do that job. Banks, so the big banks all have an in-house professional executor service. So if you had whatever $1 million or more at TD, for example, then TD would offer you that as a sort of incentive to have all that money invested with them. They say, if you don't want to name a family member's executor, because you have enough assets with us, we'll allow you to use our executor services. That's good. And I don't actually know if it's $1 million at TD, but it'll be some threshold like that. Okay. So with no will, the court appoints an executor or administrator, which is essentially the same thing. Okay. So the first question here is, does the executor accept the responsibility? One of two things can happen here. They can say no right at the outset. If they say no right away, they are not the executor, and there is no executor until somebody else is named. And they don't have to. So my suggestion here, and I know not everybody likes this, but my suggestion here is that when you write a will, you should talk to your executor at that time. It's even a good idea, in my opinion, to give the executor a copy of the will, not necessarily a notarized copy, but like a photocopy of the will, so that they have one on hand. They're not going to have to go hunting for it, and they can read through it. They can understand their obligations. Okay, I would suggest that surprising an executor is not a good thing. Are we good with that? Surprise is not a principle of estate planning. If that person does not know they're the executor, then they should. But that exact thing happens, Bonnie. People, so first off, some people have I do like it, Alicia. I do like professional executors. However, not everybody should have that. I don't have a professional executor in my case, Alicia. Okay. I don't have that much in the way of assets. I technically am in a blended family, but only my wife has kids. I don't have any kids that are biologically my own. So I don't have an ex anywhere. So it's not, for me, I don't have any reason to have that. I don't have any property outside of Alberta. Okay. But those would be some of the questions that I would ask, right? So that's a good question, Roxanne. Generally, they can pay for help. However, there are limits on their ability to do that. Okay. Yeah, it's interesting, Tricia. It's painful for both parties, isn't it? Or for all parties. So we'll talk about that right away, that stepping back. I'm curious to hear more about this. Just give me 1 second with that. Yes. And so it should be. Okay. So yeah, Roxanne, the real question there is, what does the will allow the executor to do in terms of paying for help? And I find most sort of, let's say, rudimentary wills will allow that person to pay for things like tax returns and legal filings, but not for advice. Then definitely not. Okay. But yeah, this exact thing happens where people write a will and they say, oh, it's going to be such an honor for this person to be the executor. They're going to get to, I don't know exactly what the thought process beyond that is, but that person then is surprised to find out that they're the executor and they turn down the job. It is certainly not an honor. It's a pain, Roxanne, isn't it? Okay. Anybody who has done this job, I think, will agree with that. I don't think there's ever been anybody I've talked to about being an executor who said it was a real treat. Okay. So the other thing that can happen is as soon as you start taking on some executor type responsibilities. So if you don't say no and start doing executor stuff, you're now the executor. And now you can't just decide later on to stop doing this, okay? When Tricia says she had a client or a family member, I'm not sure which it was, Tricia, but when somebody you knew backed out of this, what has to happen is, in order to, I'll say, back out, you have to essentially provide the same level of evidence to the courts as if you were closing the estate. Yeah, I can talk about that a little bit, Alicia. Yeah, I would generally avoid it. So I'll show you why in a second. First off, many of your firms have a concrete rule that prevents you from being an executor for anybody other than a family member. And some firms today even say you can't even do it for a family member. Okay, so probably 2/3 of the folks on this call have a restriction where you can't do this for anybody other than a family member. Okay. Now, that being said, if somebody decides that they want you to be the executor and you accept that responsibility, first off, if you don't have any of their assets under management, okay, if you don't have any of their assets under management, Elisa, then I wouldn't, fine, go ahead, do the job, right? There's no risk there, or there's minimal risk there, or there's the same risk as any other person being the executor. Okay. Okay, but if you have assets under management, okay, so I'll show you here, Elisa, why I don't like this. So let's say, for the sake of argument, I'm going to use you here, Elisa, okay? So let's say, and I hope I don't touch on any personal issues here, but let's say Alicia's mom has money invested with her. Everybody's with me here? Okay. And she dies and names Alicia as executor. Okay. So then I don't know, Todd, if I think that's such a bad thing. I think I'm sure that there are cases where it would make sense to do that, but I could also find you cases where it's definitely in everybody's best interest not to have that. All right, so here's the deal. So she's got an account with her. So Alicia has her mom as a client. Okay. All right. So there are 3 siblings, just for the sake of argument here. So we got Alicia, who's clearly the favorite, right? She's named as executor, so obviously, right? And Brent and whatever, Carla. Okay, that's good. So here's what happens. Alicia now, as executor, is responsible for managing the assets of the estate. That's right. She has a fiduciary responsibility to manage the estate assets. Okay, so she says, okay, I'm a fiduciary, so I'm going to be very prudent with this money. She knows it's going to take, let's say, 6 months to get the assets distributed. She says it doesn't make sense to invest for 6 months. It's a short time horizon. And therefore, I'm just going to take that money and put it into, maybe even she takes it and puts it into a 6-month redeemable GIC so she can generate a little bit of interest. Is that fair? That would be a very safe decision, and the principal is not at risk. Would you agree with that? Okay, so she does that. That's good. Let's say, though, that over the next 6 months, and this is useful for all kinds of scenarios, and you're going to see exactly why being an executor is such a headache here. Let's say over the next 6 months, the markets just skyrocket. Okay, this ridiculousness that's been happening with Facebook and Alphabet and so forth, Apple, all that kind of stuff. So over the next 6 months, the markets gain 15%. Okay. Now, are you mutual fund licensed, Alicia? Oh, I don't know. Okay, anyways, let's assume she is. It doesn't really matter. So over the next 6 months, the markets gain 15%. Okay, perfect. So what happens is Brent and Carla could potentially come back here and say, hey, Alicia, you had a fiduciary responsibility to manage this money well. Okay. You have this particular expertise in investing. You carry a license that says you're an investment professional. You should have known that there was a possibility that the markets could continue on this tear. You should have invested our money instead of sitting on it in a safe place. Okay, and I'm not saying they would do this, but we run the risk here that Brent and Carla come back to her and say, you caused us to miss out on that 15%. Our estate would have been that much, our gifts would have been that much larger if you had done that. Okay, so now let's say that Alicia saw that coming. So instead, she says, here's what I'm going to do. I'm going to put that money, I'm going to go nice and safe. So she goes and she chooses a balanced portfolio. Okay, puts the money all into a balanced portfolio instead of the redeemable GIC. Everybody's with me here? Okay. And she does it, of course, under her own license. She sells it to herself. Now, you're not going to get rich on 6 months of trailer fees, right? Everybody with me here? But Brent and Carla come back and they say, hey, Alicia took that money, she invested it, she earned a trailer on the investment of that money. That influenced her behavior. She would have paid that money out to us sooner if she hadn't been getting that trailer, or she took some risk with it that she should not have taken if she wasn't getting that trailer commission. So therefore, we're going to, and it might not be the whole complaint. This might be something that works its way into a larger complaint about maybe a lack of timely distribution of assets. Okay. So the concern here is really that all of you on this call have some degree of specialized knowledge, and in a hindsight type of decision, which is what we typically get where somebody's in a fiduciary role, then the people who are suing you can essentially use that specialized knowledge against you. Good? Okay, yes. So, right, but I showed the risk with that grant, right? I could have done 6 months, I could have done a cash account instead of 6 months GIC. I'd still have the same problem, Grant, right? I still missed the 15% gains in the markets over that 6 months, right? So there's a risk no matter what. Yeah, I know it could have dropped, but yeah. And again, there's a risk there, right? You see, I could paint another scenario where you put the money in the markets dropped, and, right? So no matter what, there's risk there, okay? And you're not well served by your expertise here as far as that sort of connection to possible liability exposure. Okay. Honestly, if I were any of you, no matter who asks me to be an executor, I would probably just lie and tell them that my firm does not allow it under any circumstances. Okay. That's good. That is the safer option, Grant, but I showed how that could still expose you to risk, right? All right. That's all good? Right. Yeah, that's why we talked about the family member scenario here, Grant, right? Okay. Yeah. And you might even run into a problem here, Alicia, where if you get sued for this, your E&O insurance might not be helpful. Okay. All right. That's it, Grant, which I think is a good degree of protection. Okay. All right. Now, once the executor accepts the job, so now what does the executor do? Well, they're going to often be responsible for funeral arrangements. They're typically going to apply for your CPP death benefit. We're going to notify Service Canada if there's CPP and OS being collected. Of death, any other entities that are paying benefits, if this person's on a workers' comp claim, for example, you would notify workers' compensation. So whoever is paying benefits has to be notified so those benefits can be terminated. Then we're going to gather the assets and gather the liabilities. So there's an active effort here to make sure that we are aware of everything this person owed and owned. We're going to get an accountant to estimate the terminal tax bill and the estate tax bill. when those things become possible. You're going to distribute assets. Yep, exactly, Bev. If there's an annuity being paid, you notify the insurer, 100%. Yep. We're going to distribute assets to any beneficiaries who are in dire straits. So if you have a beneficiary who, for example, is counting on some money from the estate to help pay their tuition, and if they don't get their tuition paid, they're not going to be in school this semester, you may, as the executor, make a choice to distribute some funds to that person. If you didn't, then that could be a source of liability for you later on. Okay? Or if somebody had to get it to pay rent or buy groceries or whatever, something like that, that creates an artificially short time frame. Then you're going to pay any debts. Now, if there's not enough money to pay debts, that's where you may have to take the estate through a bankruptcy. Okay, that's good. And then you're going to distribute assets. Now we'll talk more about distribution of assets later on. There's a bunch that goes into this distribution of assets. You generally are going to hold back some in case you didn't get all the debts handled, in case you misestimated the taxes, whatever the case is, and then you're going to wind up the estate. Okay. Now that is a gross oversimplification compared to the real process, and many of these steps are going to take weeks or months, and there's going to be a bunch of effort and paperwork associated with it. Nothing here is going to be so simple. And I didn't mention some of the more, I don't know, routine administrative stuff. So even just things like making sure if there was a house that the utility bills are taken care of, or to make sure auto insurance and auto registration are properly taken care of. Really, every asset that this person owned, the executor is going to have to somehow figure out where it goes and how it gets there. Okay. Any questions there? All right. Then we look at an intestacy. So intestacy means you died without a will. You didn't establish your estate wishes. So no will, or died with an invalid will, a will that wasn't signed, for example, or a will that was written not respecting the conventions for the province you died in, or whatever the case is. No, in fact, Shade, there's no legal requirement to pay your executor. Okay, so you could easily write a will that leaves nothing to an executor. A properly written will is going to contemplate how the executor gets paid. Okay. Nobody gets rich off of being an executor for one estate, Shade. All right. At least they shouldn't. Okay. There are these stories of people who are in an executor capacity questionably enriching themselves. I know that happens. All right. Yeah, we didn't talk about actually appointing an executor yet, Paul. We're going to talk about that later on, about appointing a good executor. But I would suggest that even it goes a step further than that. I do agree with you. it's ideal to have an executor who is local. And I would suggest that that even extends to an executor who is close to you geographically, not just in Canada, but it would be ideal if you die in Nova Scotia, if your executor is a resident of Nova Scotia as well. Yeah. Although, Philip, I would, like, if it's PEI, I would suggest you're probably okay to have somebody in New Brunswick. Okay. That's good. Or maybe in Nova Scotia, depends how close they are to the bridge, I guess. But I don't want to have that person having to haul all over the country, because they are going to have to attend to the courts in person periodically. I don't want them having to haul all over the country to deal with whatever has to be dealt with. The Atlantic bubble, there you go. Okay, so this person dies intestate, no will or an invalid will. So now, and it can actually happen, we can have a partial intestacy as well. And this is where your will is fundamentally okay, but there's a portion of your will that's no good. Okay, and this can happen today in Alberta. For example, in Alberta, and actually BC has the same set of rules around this. When I get married, it no longer revokes a will, okay? In other provinces, if you get married, it revokes any existing will. Even in Saskatchewan, becoming common law revokes your existing will. So what does happen, though, in both Alberta and British Columbia is if you've named your spouse as a beneficiary and then you get divorced, capital D, divorced, okay? So you named your spouse as a beneficiary and you get divorced, then your spouse is going to have no rights to anything in the estate. So if you didn't change your will after that divorce, then any chunk that's described as going to your spouse would fall under partial intestacy rules. Okay. Yeah, and Grant, that goes back to my comment earlier. People think, oh, it'd be nice if both of my kids were executors, because then, you know, they'll have no fights or something like that, right? But in fact, what that person really did by naming that was saddle their BC son with a whole bunch of extra cost and administration, and really probably put them at a disadvantage compared to the other executor. They probably just did not have access to the same information and yet had to be subjected to the same degree of liability. Okay. You mean not updating the will after a divorce, Nicole? It's one of those things, isn't it? Okay. So just back to my intestacy then. Oh, naming. Oh, yeah, I gotcha. Sorry. Yes. I had two parallel thoughts going on there. But that, yeah, 100%. That's a thing people do, right? And you would see that with your farming clients, wouldn't you, Nicole? Okay. On the plus side, Grant, I'm sure that some courier company made a lot of money on that deal. FedEx or whomever, right? Okay. Yeah, as long as they do it right at the beginning, Todd. Yeah, nice, Grant. Yeah, as long as they do it right at the beginning, which again, people don't often think about. And that's going to be one of those messy things where, you know, the local brother started to do some things. The other can't necessarily opt out at that point without saying, hey, look, I'm leaving, and I'm leaving where everything is in good standing. They probably still have to demonstrate to the courts that they didn't mess anything up before they're leaving. Okay, yeah, I'm not generally a fan of that multiple executors thing. All right, so what happens in an intestacy? Well, the first thing that has to happen is the courts will appoint an administrator, which is really our executor. Okay, so the courts are going to step in and say, you didn't bother to name an executor. Now it's the same deal. This person does not have to do the job. So they can tell the courts, no, I am not acting in that capacity. And actually, I just gave somebody this advice. It's a weird one, but a friend of my neighbor's, she and her husband, and they have kids together, separated in the fall, almost a year ago now. And then he died by suicide in about February. He died without a will. And the courts tried to get her to do the executor job. He has a bunch of debts. I said, do not do that job. So she and I had a whole bunch of back and forth on this. And that's one of the things that, and I think she ultimately did manage not to be doing that job. So there's no benefit to her to be the executor. Okay, so now that being said, if it's your parent and it's sort of you and one sibling who are going to inherit the estate, maybe you do it, but I would prefer to get my sibling to do it. Okay. So now once the executor is appointed, or the administrator is appointed, it really follows the same path as the executor from the last slide. The difference here is there's going to be a higher level of accountability expected. Because it's an intestacy and there's no court documents to describe how this works. So the bigger question, or the big question that we typically think about first here anyways, is if I don't have a will, who gets my stuff? Now this varies by province, okay? That's good. So it does vary quite a bit actually by province. If we're looking at Ontario, for example, so in Ontario, what's going to happen here is the spouse gets the matrimonial home. That's the first thing we're going to see. If there's a house, it goes to the surviving spouse. Okay, so this is a messy one, Paul, right? And this is where the rights sometimes extend to a common law partner and sometimes don't. And that's going to vary by province, and that's another reason to get divorced. All right, so surviving spouse gets the matrimonial home. That's good. And then they're going to get, now, if there are no kids, they really get everything else. The spouse gets everything else. However, if there are minor children or children who are dependent for other reasons, okay, those minor, then what's going to happen is the spouse gets the first $60,000, what's called a preferential share. And then we split what's left, and it's either going to be half to the spouse and half to the kids. If there's one, to the kid, if there's one kid, or a third to the spouse and 2/3 to the kids if there's more than one child. Okay, and the fractions don't keep increasing like that. It's just 1/3 to the spouse, 2/3. Those are the only two possibilities. Okay, that's good. So that's one example of a intestacy regime. It's different in Alberta, for example. So Alberta, here, if you die and leave behind a spouse or common law partner who is the parent of your minor children, that person gets everything. Okay, that's all good? Now we're going to talk about this more after the coffee break, which is still a little ways away, Todd. In 2013, Shauna. That changed in February of 2013. Yeah, because you're right. There used to be a regime more like the Ontario regime in Alberta. Yeah. Okay. In all cases, if you die and leave behind a dependent who is not taken care of, that person may be able to challenge the estate. Okay, this is what we would refer to as a dependence relief claim. That's good, and I'm going to show you some examples of that, like I said, after the coffee break. All right, any questions about intestacy? Okay, let's keep going then. So now we have to look at the consequences here of taxation at death. We're going to marry up our two certainties in life, right? And look at how this works. And we did this once before. We did this back in chapter 9, but I'm okay to do it again. So first off, just like I did a few minutes ago when we talked about the estate, we're going to divide this up into two portions. And for the sake of simplicity here, we're going to have somebody who dies on the 1st of September of 2020. Okay. So what happens then is, as of the date of death, okay, really midnight the day before you died, all your assets are deemed disposed. Now, just like any other time, we can potentially have access to a spousal rollover. So remember, you can always transfer assets to a spouse on a rollover basis. If you're married or in a common law relationship, then we can flip those assets over to that person, no disposition required. In order to deal with the tax consequences of this person's death, we can have up to 4 tax returns filed that would all be based on that 1 September year end. Okay, the one that we almost always have to file is just the basic terminal tax return. But we can also have what's called the rights and things return. And then we get into our more obscure returns, which would be for the final beneficiary of a testamentary trust, and for a partner in a partnership. These bottom 2 returns are quite rare. You wouldn't see them used outside of a narrow set of circumstances. The top 2 returns are a lot more common. and especially the terminal tax return, that's the obvious one. So your terminal tax return is going to cover your income earned in the year of death. So if you were working and you died 10 months into the work year, there's 10 months of wages that have to be taxed. Although technically there's a small amount of your last paycheck that can actually go on to the next tax return, the rights and things tax return. We would also cover any dispositions of assets. So we know that when you die, that triggers the capital gain on all your property, unless you take advantage of spousal rollover. Okay. All right. Then we have our rights and things return. So our rights and things return is a little weird. Yeah, I know he's right here, Bonnie, saying hi. All right. So our rights and things return is where we're going to include amounts that were paid but not earned in year of death. Okay. So the most common example of this will be vacation pay. If you have banked vacation pay, your employer may not have intended to pay it this year, but you die and your employer says, well, we can't hold it back anymore, better give it to that person. The only reason you're getting it that year is because you died. So it wasn't earned in that year, but it was paid in that year. Okay. Other common items you see on a rights and things return are your final CPP and OAS payments, which are technically paid at the end of the month in which you die. So this person would actually get a CPP and OAS payment for September, and those are amounts related to that person's death. They're not really your monthly income benefit. Okay. That's not the CPP $2,500 death benefit. It's your final CPP monthly pension benefit. And then for the farmers in the room, we would also be allowed, and this can be a big one, if you have crops in the bin. So you've gone out, brought in your crops from harvest, they're sitting in the bin waiting to be sold, but they haven't yet been sold, you can put that onto a rights and things return. Now, why do I care about the ability to file more than one tax return? It's income, so it's still taxed. Exactly right, Melanie. Yep, you're 100% correct. I'm paying tax on it. The question is only what return am I putting it on? So my rights and things return, it's not tax-free. So this is the point here, right? The point is that really what I'm effectively doing is income splitting with myself. I become one taxpayer on the terminal tax return where I'm using my graduated tax rates. I become another taxpayer on my rights and things return where I'm using my graduated tax rates, again, starting from zero. So for the sake of argument, if you die with, let's say, yeah, that's exactly what it is, which is useful, right? So let's say I die at age 70 with a spouse. So I have a spouse, I'm going to say 73, okay? With a spouse, and that year I had, I don't want to make this too complicated. I think I can get away with this here. So that year I had my $20,000 RIF minimum. So that amount has to be taxed. I had, up till September, I would have had about $6,000 of CPP, about $4,500 of OAS. Okay, you with me there? No other income. Well, what I would end up doing here is I would put, and this is going to be approximate, so bear with me, but on my terminal return, I'm going to put the $20,000 plus most of the CPP and OAS. So we'll call that $5,400 of CPP and $4,000 of OAS. Okay, and then on the rights and things return, which I'm going to have to jump through whatever hoops to file, it's still a tax return, but on my rights and things, I'm going to have $600 of CPP, my last CPP check, and $500 of OAS, my last OAS check. What that'll effectively do is make that $1,100 tax-free, because I'll get the basic exemption a second time. Which really allowed me to put up to $13,000 there tax-free. I just don't have $13,000 that can go onto that return. So I can get the basic exemption a second time, and I can get tax rates starting from 0 again. That's good. So that's why I would do that, right? Because I really am income splitting with myself. There's actually 5 tax credits that you can use on both tax returns. Yeah, exactly, Melanie. So the basic exemption, you can also have the disability tax credit on both returns. You can have the amount for an eligible dependent on both returns. I'm missing 2, but you're exactly right, yeah. Oh, the disability amount transferred from an eligible dependent and the age credit can go on both returns, okay? Not that this person needs all those tax credits, they only need the basic exemption, right? It's only $1,100 of income. But you would save whatever it is, $300 by filing that tax return. Okay. That's all good? Now, what's the filing deadline for the terminal tax returns? When does this set of returns have to be filed? So what's the normal filing deadline? Yeah, that's it. You have April 30th to file and pay for most people. That's still true here. You'll have April 30th of next year. Okay. If self-employed, then June 15th, Shauna. Yeah. Yeah, exactly true, Paul. If you had a corporation, we're going to talk about that in advanced curriculum, Paul. Yeah, exactly right, Melanie. Yeah, that's exactly what there is. It's never, so it's April 30th of next year, but never less than 180 days. Okay, so if you die in November or December, then you would get longer. Your executor would have longer than April 30th to file. Okay. All right. It is April 30th though, Cam. Yeah, it really is April 30th. Unless you're self-employed, if you're self-employed, then you have until April 30th to pay and until June 15th to file. Again, never less than 180 days. Okay. All right. Does that all make sense? Okay. So now, we're going to switch gears and look at the estate. So remember, the estate is a separate entity. It's you without the fleshy stuff that's sitting on the keyboard right now. Okay, so your estate comes into existence after death. And remember I said, estates can sometimes go on for years. And it's a separate taxable entity. You without you, Philip. That's right. Okay. So the way the estate is handled for the first 36 months after death, we're going to have what's called your graduated rate estate. Okay, so your graduated rate estate still has access to the marginal tax rates. And it has a year end no more than 12 months after your death. So it can choose any year end up to 12 months after death. Most likely in this case, it would choose either, well, probably almost would certainly choose August 31st. Okay, that's good. Your executor then, at the end of each of those 12-month periods, is going to have 90 days to file and pay each tax return. Okay, that's all good. After that 36 months has passed, if your estate is still around after 36 months, then it starts having to use a December 31st year end, and any income it earns is taxed at top marginal tax rate. That roughly 50% tax rate, depending what jurisdiction you're in. Okay. Does that make sense? Perfect. We're going to do a lot more work around this in advanced curriculum, but for now we have a sufficient handle on it for what we need at this point. It doesn't have to, Cam. Once you're past that third year, then it's always December 31st and then 90 days. But in that first 36 months, it can be any year end, no more than 53 weeks actually from the last year end. Okay. All right. So yeah, it can sort of pick and choose its year end within that year. I don't know why you would change it after the first year. It seems messy to me, but who knows? Okay, so then we look at some cross-border issues. Now, we already covered this off. There's already a few good questions about this. I don't have much more to share with you here. I will point out, so we're going to deal with our most common sort of concern here. There are roughly 1 million US persons living in Canada. Anybody on the call a US person? So there are really two things that can make you, two ways to be what we call a US person for tax purposes. Okay, the first is, and the one that you're probably more concerned with for most of your clients, everybody on the call has a client like this, okay? It's nearly a statistical impossibility that this isn't true. So the first way that we can see this is somebody who was either born in the United States or born to US parents, but born anywhere in the world. Now, there are a bunch of rules around this. There's a different set of rules for somebody who was born prior to 1986 and born after 1986. There's a different set of rules depending how long you lived there after you were born in the United States, if you lived there as an adult or as a child. So there's many, many sort of underpinnings to these rules. And I would point out that every case is different. Or the other way that you can become a US person for tax purposes is by spending a bunch of time in the United States. So born in the US or born to US parents. So if you become a US resident, okay, and there are really two ways to become a US resident. One is, or my item A on my list would be to fail the substantial presence test, or some people would say pass it, whatever. I'm going to say fail the substantial presence test. Okay, so fail the substantial presence test means that we look at your days in the United States 2 years ago, last year, and in the current year. We apply a formula to each of those days. We would look at, so that doesn't make you a US person for tax purposes, Paul, but it can trigger something else. Hang on to that thought. All right, so we take that times 1/6, this times 1/3, and this times 1, essentially. Just count those days. And if the total of that count, if the total on that math is greater than 122 or greater, then you are a US person. Okay, that's good. However, most people actually don't rely on the substantial presence test. So if you fail the substantial presence test, but aren't really a US person, you still have what we call closer connections to Canada. So you would say, where's your family? Where's your job? Where's your healthcare? Where's your house? Okay, all the things that we would really look at to determine where you live. Then you file the closer connections test. To stay a resident of Canada. This is very limited, however, in its effect. You can probably get away with this for maybe 3 or 4 years, but if you're continuously spending so much time in the United States, they're eventually going to say, we don't believe that substantial presence test thing anymore. Okay. Now, once we've established that, that means that if that US person, I'll come back to your point in a second here, Paul, you have absolutely some validity to what you're saying. So if a US person dies they are subject to US estate tax. And what happens here is if they have property, and it's a quite large limit here, worth over about $12.8 million worldwide. Okay, so we look at all their worldwide assets, and if they have property worth over about $12.8 million, they are subject to a 40% estate tax. Now, there is a spousal rollover available here. So if you have a couple who are both US persons, they really have a $23.6 million exemption. That being said, if you had a client who was a business owner, a farmer, investor, a highly paid person, and they have this US connection, they need some extra work done on their estate plan. Okay. Now, Paul is right to suggest this. If a Canadian, so a resident of Canada, who is not a US person, can be subject to US estate tax if they fail 2 tests. So what has to happen here is they own more than $60,000 of US property other than personal use property. Okay, now the test for that is quite difficult, and they own more than 12,800,000 of worldwide assets. Okay, now I don't particularly care about these rules. That's not the point. Okay, don't go memorizing these just yet. When you get to advanced curriculum, we'll do these and a bunch more. The point here is that there are many regimes like this or jurisdictions like this where once you own property in that other jurisdiction, it's going to add this layer of complexity to your planning. Okay, it might not just be additional cost. It might be that there's restrictions on how you can pass property. Some countries still have rights of primogeniture, which means property has to pass to the eldest male child first. Okay. A lot of countries that follow the French legal tradition don't have trusts. France does actually. France introduced trusts in 2014, but countries that don't have trusts make it very complicated to use a Canadian will hand in hand with an American will. So Todd, it would be both of those things. You see, it's both of those tests.
Oh, you have to have both.
Yeah.
Okay.
Yeah,
So
it's not
if they own multiple properties in the US, but it doesn't add up to 12 million, then they don't have to worry.
All their stuff would add up to 12 million.
Okay. No,
that's including your Canadian property. And the notable thing here that often throws people off, Canadians off, is that 12.8 million includes the value of any death benefit paid as a result of your death.
Okay.
So if you've got a client, you might have some of this. You've got a client who's got $10 million of assets and maybe a $5 million insurance policy, that would put them over. Okay. All right. Any questions there? Okay, that's probably a good time for a break. After a break, we're going to come back and talk about estate planning and setting objectives, and then we're going to move into some particular concerns with wills. So I have 26 minutes past the hour. Let's take a 15-minute break. We'll resume at 41 minutes past. See you then. Yeah. All right.